You want an attorney, Mr. Grigsby?
No, sir.
I didn't think so.
I'm not. Excuse me. I'm not. Again, I'm in special appearance of Contra Grigsby, and no.
Well, I need Contra Grigsby. Grigsby. So whoever, if you're not Contra Grigsby, then we're gonna put a warrant out. We're gonna put a warrant out for your arrest.
Well, I'm in special appearance of Contra Grigsby, and whatever.
Right, so I have Contra Grigsby.
Like I said, I'm in special appearance of Contra Grigsby.
City of Detroit versus Contra Grigsby. Case number SP168333921. SP1683393, counts 1 and counts 2. Appearance for the record, please.
And special appearance of Contra Grigsby Jr., Suri Juris and Proprio Persona.
That went over my head.
No rights. I do not waive none of my rights.
All right, Woody is the date and time set for a pretrial. What do you want to do with these cases?
Should be taking it. First, I want to I have added 2 pieces of documents to the court. I want to put them on a record. And my affidavit of conditional acceptance and my Naturalization Act of 1779 I already had on the record. So
Before we even get into this courtroom chaos, let me set the stage, because what you're about to watch is a perfect example of how confidence without comprehension plays out in real courtrooms. In this video, we jump between 2 very different but strangely similar defendants. First, we meet a self-proclaimed sovereign citizen in Michigan who believes saying the right magic words can make legal consequences disappear. Spoiler alert, they can't. Then we head to Lake Forest Park, where a defendant spirals into confusion, blaming everyone from his attorneys to an ignition interlock company for his legal problems, while missing the one thing that actually matters: compliance with the law.
Henry James Matter, 3A0817981.
In your honor, at this point, I would ask the court to allow me to withdraw. Mr. James did file a bar complaint against me. I feel at this point I have a conflict.
Mr. James, go ahead and activate your audio.
Yeah, I have no problem with that.
Well, I have a problem understanding what's going on. So you had previous counsel with SMH. You were then given conflict counsel with Mr. Smith. Are you planning to hire private counsel?
No, ma'am. I didn't ask him to withdraw.
Yourself?
No, ma'am. I didn't ask him to withdraw. He took it upon himself to do that. I have nothing to do with me.
Did you file a bar complaint against him?
Yes, I did.
Okay, and how do you think that's going to affect your working relationship with your attorney?
He needs to do his job. It was some things that you informed him to do that he did not do. For us getting the evidence for me to prove that I didn't commit this crime that you guys got me charged with. He was supposed to get in touch with Intoxalot. You told me that he don't have to get in touch with Intoxalot. I'm of the belief that's his duty to get in touch with Intoxalot to find out what's going on. And he haven't done his job. And he made that decision. It wasn't me this time. He made this decision. I can't afford an attorney. I need another attorney.
Well, we don't have unlimited attorneys to give you. It sounds like you have issues with the attorneys that get assigned to you. And that began...
That's not my fault.
Well, it sounds like it might be something that's related to you more than the attorneys, since you've now gone through 2 attorneys. So, Mr. James, I don't know how we're going to proceed on this case. We don't have unlimited attorneys that are contracted with this court to assign to you.
That's not my fault.
Well,
if you're going to tell the attorneys that they don't have to help me, then what am I going to do? You told me in open court December the 16th that they don't have to do anything for me.
Right here is where things immediately derail. The defendant isn't just declining an attorney. He's attempting to invent an entirely fictional legal identity. Special appearance, Contra Grigsby, and this bizarre verbal shell game are classic sovereign citizen tactics. The idea is simple. If they can claim they're not the real person named on the case, they believe the court loses jurisdiction. But here's the problem. Courts deal in reality, not linguistic gymnastics. Judges hear this exact script constantly, and it never works. What makes this moment especially telling is the judge's patience.
And
But what was
you
you
need
referring
to
to?
how you.
What was you referring to when you said that? When
Well,
you said
I
when
think I
you
said
stated
that.
that my turn is, what was you referring to when I told you that I needed them to get in touch with Intoxilot? These are the people that are holding me in here, bringing false charges against me. Everything they charged me with, I served my punishment on that already. With Intoxilot charging
Those are
me
two
with.
different things, Mr. James. You are charged with driving on a suspended license. The issue is whether or not the Department of Licensing suspended your license, whether you were given notice and due process, and the information pertaining to your status and whether you chose to drive after the fact. Those are the relevant issues. So you may have other concerns. I don't know your situation with Intoxilot. I know you have a beef with them about whether or not they conveyed information to someone. I believe that's what you've said previously.
But you guys are their enforcers. Y'all enforcing Intoxilot. I just spoke to DOL. They say they're not going to get involved with what's going on with me in Intoxilot.
That's right.
You can't make
Personal
Intoxilot give
with
them the
Intoxilot.
compliance.
That is not, that's whether or not you had a valid license on the date of violation is the question.
This is where sovereign citizen mythology really shines, or collapses, depending on how you look at it. When a defendant starts referencing affidavits, conditional acceptance, and even the Naturalization Act of 1779, it sounds impressive to people unfamiliar with legal history. But to a judge, it's noise. None of these documents override criminal procedure, municipal authority, or jurisdiction. This tactic relies on overwhelming the court with paperwork and archaic references in hopes that something sticks. It never does. Courts operate on current statutes, not cherry-picked.
They told the DOL informed me that they didn't suspend my license. They can't make Intoxilot give them the compliance. And Intoxilot sent me a settlement letter saying if I paid $139, I will receive my license back. I paid $139. They still haven't given me my license back. So they led me to believe if I pay this amount, they would give me my license back. The amount was paid, and they still have not gave me my license back. Now they're saying it's something else.
No,
They've been playing this game
still
with me for
showing
years.
up suspended, Mr. James, as of right now, and there's a reinstatement condition that you have ignition interlock with compliance for at least 4 months. That is
The
a
court said
requirement.
I complied. The sentencing court said I complied with the 4 months.
What citizen court? I don't know what you're talking
The
about.
court that sentenced me in Seattle District Court. Seattle District Court said I complied with my 4 months. They said they was monitoring me at the same time Intoxilot was monitoring me. They both had my car under GPS monitoring me. And the court that sentenced me to the 4 months, they said I complied with my 4 months. They said that they had a tab on me just like Intoxilot did. They said I'm finished. I talked to the clerk of court. They said they also was GPSing and monitoring my car during the same 4 months Intoxilot was. And they said I completed the 4 months. So if the court was monitoring me at the same time the Intoxilot was monitoring me for 4 months, the court said I completed it. Because if the court otherwise,
What are you talking
otherwise
about?
they would have turned over.
Mr.
Otherwise,
James.
they would have notified
Mr. James,
DOL to suspend my
Mr.
license.
James, what court are you talking about? I think you hear what you want
King
to
County
talk.
District Court. King County
Okay.
District Court, the court that sentenced me on the DUI charge. There is no other court, ma'am. The court that sentenced me on the DUI charge. The court that sentenced me to the 4 months compliance with the DUI. No more than 4 months. It could have been less than 4 months. It was on my car. The court that sentenced me
That was back in
was monitoring my car.
Right? The 2015
Yes, ma'am.
case, you were sentenced in 2018.
And here comes a reality check that so many defendants don't see coming. The request to handle the case in private is another common misconception. Courts are public institutions by design. Transparency is not optional. It's mandated by law. This isn't negotiation or a preference. It's constitutional structure. The judge shuts this down cleanly and professionally, reminding the defendant that jury trials and hearings are public for a reason. What's important here is how smoothly the judge transitions the case forward. There's no emotional reaction, no debate, just procedure.
The court said they monitored me the whole 4 months I had the thing in my car. That was the court that sentenced me. That's Seattle District Court, the West Division. I talked to the clerk of court. They said they monitored the whole 4 months it was in my car. They said, and they sent me an order saying I successfully completed the 4 months. And that this case is closed. So if the court is saying I'm finished,
Mr.
and the
James,
Toxalot is saying I'm not finished, we have to go on what the sentencing court is saying. I'm going on what the sentencing court is saying.
Well, then you are doing that to your detriment. So if you choose not to listen to your attorneys, you are still showing suspended. Your status is
My attorney haven't told me anything. My attorney is not even talking to me. He won't even get in touch with me. He haven't told me anything. One attorney said, Sean Parent said, I need to put it back in my car 11 more months. It was already in my car 14 months. And you keep saying I have to put it in there for 4 months. The machine was in my car for 14 total months until they was ordered to take it out of there. Had I would have taken it out, a warrant would have been placed for my arrest. I didn't take it out.
There could be two different things going on. The court may have ordered you to have an ignition interlock device as a condition of your release while the case was pending. If you entered a guilty plea to the DUI or were found guilty, then the Department of Licensing will impose certain restrictions based upon your plea. And that may be what's going on.
I did everything. I took the classes. I took the DUI classes. I paid all of
and I think your
victim fund.
DUI,
I did everything, all that. I did all that already.
Okay. If you would stop talking, I think your DUI case is closed. But you still have obligations to the Department of Licensing. They have their own systems in place. And
they told me I don't. They told me I don't. In a recent email that I got from them 2 weeks ago, they said they have nothing to do with this. They don't want to. They say this, everything that's going on, DOL told me, is between me and Intoxalot. They say I broke the conditions of Intoxalot, not DOL. They say that Intoxalot saying I broke the condition.
Now we shift to a completely different defendant, but the underlying problem remains the same: refusing to accept responsibility. Filing a bar complaint against your own attorney is not a power move. It's a nuclear option. And once you do that, the working relationship is essentially over. Attorneys cannot ethically represent someone who's actively accusing them of misconduct. What stands out here is the judge's observation that this is now the second attorney with whom Mr. James has had issues. Judges notice patterns, and when the common denominator is always the defendant, that matters. Courts do not have unlimited lawyers on standby.
so, Mr. James, it appears to me that Intoxalot is not going to show that you're in compliance for whatever reason, and that is your beef with Intoxalot. Okay? But if Intoxalot is not sending the proof to the court or to DOL, it's not the court, it's to DOL, then they're not going to lift the restriction. They're not going to show that.
I understand that, but it's DOL is not holding my DOL is have to go by what Intoxalot said.
Right. And
Everything you saying,
DOL does
I
not have proof. DOL apparently does not have proof that you have the 4 months compliance.
Well, I told them they can contact the sentencing court. The sentencing court has the proof.
That is
Otherwise,
not,
they would have never told me. Not
the same. So, Mr. James, if you choose to just disregard what people are saying to you, you're just...
I'm going by what the law is saying. It's obviously you're not following the law, Your Honor. You're not following the law. You're upholding something illegal for Intoxalot. You're helping them mess over colored people. That's what you're doing. This is a racist act by you and Ms. McDonald and your entire courtroom. Y'all doing this against... Y'all don't do this to the Caucasians. I have sat in your courtroom. I have watched you not give Caucasians the Intoxalot machine. You did not put that in a car. Instead, you'll give them a fine. But every colored person come in your courtroom, You want to put this in their car and hold this against them the rest of their life. If Intoxilite had authority over me, then that means I'll have that thing in my car the rest of my life. If you give them the authority and you uphold Intoxilite authority, it's obviously you own Intoxilite in payroll. So it's obviously Intoxilite is paying you to mess with colored people. And that's what's going on. They paying you to mess with colored people and to keep that on their car.
Because you're saying a lot of things that don't make any sense at all. I'm not doing this to persons of color. That is simply not true. I'm not
doing this to everybody over the United States of color.
I don't have anything to do with Intoxilite. I don't think DOL cares.
You upholding a legal. First of all, no law should be enforced that deny me privileges and punish me. You can't use a law against me to keep denying me of privileges, and you intentionally doing it, Your Honor. You're intentionally using some old piece of law that somebody said to deny me privileges and to constantly punish me. I've been found guilty. I done served my time. I did everything. The court said I complied with the 4 months. You started telling me about another punishment.
This exchange perfectly captures one of the most misunderstood constitutional rights, the Sixth Amendment. Yes, you have the right to legal representation. But no, that does not mean your attorney must follow your instructions or adopt your personal strategy. Lawyers are obligated to act in your best legal interest, not simply do what you demand. The judge clarifies this with surgical precision, dismantling the defendant's claim without raising her voice. The key phrase here is, "You cannot dictate legal strategy." That's the line many defendants refuse to accept.
You can't use a law, nobody can enforce a law in violation of my due process rights. Nobody can use a law to continually to deny me of my driving privileges. All this about some other shit and this other person and that person, they don't have nothing to do with our Constitution.
James, I'm concerned.
That has nothing to do with our Constitution.
Do we need to have
You
a
can't keep using
forensic
the law
evaluation?
to deny me privileges. This case been going on for 10 years. I'm still on my first offense DUI for 10 years. Common sense will tell you this is ludicrous. This is bull crap. You can't keep using the same case to punish me.
Mr. James, you've been muted. I'm concerned whether or not we need a forensic evaluation. I don't know. I mean, I think Mr. James is just angry with the system.
Well, Your Honor, the bottom line is he didn't fully pay the interlock people. I think he paid a settlement amount, and somehow that letter did not get to DOL, or they didn't uphold their end of a partial payment to give the information that he did his ignition interlock to the DOL. So that's, I think, where we are.
But that is not a situation that I have any control over for him and for his relationship with Intoxilite. Mr. James is facing a new case in King County District Court.
This is the core misunderstanding driving the entire case. The defendant believes that because his DUI court case was closed, all related consequences automatically disappeared. That's simply not how the system works. Criminal sentencing and administrative licensing are separate legal tracks. Completing a DUI sentence does not instantly restore driving privileges. Interlock companies like Intoxilite report compliance data to the Department of Licensing. If compliance is reported or conditions change, the license remains suspended.
And I can see that would be very frustrating if he has complied and it's simply a matter of not paying. But the Department of Licensing is the one for any future release of his driving status. Let's see.
I just paid them their money in January, and then they came with they gave DOL some information to give me last month, saying that I did something on May 23rd of 2022. Right after I paid them their money, right after I gave them their last payment, they sent me a settlement offer that if I pay this $139, that is over with. Right after I paid them, they close my account. They close my account with Intoxilite. Then when DOL talked to them, they open the account back up and say I did something else wrong. So you can't keep enforcing the law to keep denying me of my account. You can't keep denying me privileges like this, enforcing this law against me over and over again, the same law, the same case over and over. You can't keep doing it.
Mr. James.
I think we're ready for federal court. I think we can take this to federal court.
Mr. James,
Because
we are
y'all
in a
don't respect
position-
us.
we are in a position right now where Mr. Smith has made a motion to withdraw due to a conflict given the bar complaint. And I think that we could be here all afternoon with Mr. James voicing his frustrations. So I think we just need to handle the issue of the conflict and figure out conflict counsel and go on from there and move it to the next jury term so that conflict counsel can get up to speed. Speedy trial under the rules would restart today with the conflict. So I would ask for that calculation as well.
At the end of the day, both of these cases highlight the same hard truth. Courts operate on facts, records, and statutes, not personal interpretations, internet theories, or selective memory. The first defendant tried to talk his way out of jurisdiction. The second tried to argue his way around administrative law. Neither approach worked. Judges were patient, clear, and methodical, but the outcomes were driven by compliance, not confidence.